Well, good morning, everyone. Thank you for joining us. My name is Brad Williams. I am the Vice President of Government Relations at the Detroit Regional Chamber. And we're so happy you chose to spend some time with us this morning to talk about an issue I know is top of mind for employers everywhere, including Governor Whitmer, if you read the news over the course of the last couple days. And that is the proposed vaccine mandate for employers. We have with us today Jim Herman. Jim is a member at Dykema, one of our great law firms in Michigan, who specializes in labor and employment law. And we asked Jim to come in and spend some time with us to really help some of our members understand the status of the vaccine mandate, some of the specifics of it, because we understand it is complicated, it is confusing, and we want to help you navigate around this. So Jim, thank you so much for spending some time with us. I think to start it out, and I apologize, I need to rewind a second. I know you have questions. When you look at the GoToWebinar, there is a question box. Please submit them. I am monitoring them, and I will ask them of Jim when the time is appropriate. So with that, Jim, I'll return to you.
Sure.
Jim, Governor Whitmer earlier this week said that this vaccine mandate is difficult even for her as a employer with the state, someone who's been very aligned with President Biden politically for the entirety of the administration. The U.S. Senate voted this week 52-48 to overturn the vaccine mandate. Could you just give us a status check on where we sit with this? So, folks who maybe don't open up the newspaper religiously and read it like I do can just kind of understand the context under which we're talking today.
Sure. So the emergency temporary standard was issued with a couple of deadline dates, one of December 6th, one of January 4th for the employers to do things. Before those dates came, there were lawsuits filed all across the country in virtually every circuit court, and that's the procedure that you use to oppose these ETS. It's an emergency technical standard under OSHA. And almost every circuit had motions and lawsuits filed in it saying this ETS should be stayed and overturned. Eventually, the Fifth Circuit entered a stay saying these aren't going to go forward because we have some grave concerns about whether or not they're enforceable under the language of OSHA. Once the Fifth Circuit entered that order, and actually it was 2 weeks after the ETS was issued, there was a lottery that was held, literally ping pong balls put in one of those cage things where they pulled in one circuit out that had objections filed, where all the cases were going to be consolidated and transferred. And they were all transferred to the Sixth Circuit, which is the court in Cincinnati. It covers Michigan, Ohio, Kentucky, and Tennessee. So all of the objections are being determined by the Sixth Circuit. Briefing on those objections is scheduled to end tomorrow, December 10th. The Biden administration asked for expedited consideration. The Sixth Circuit said it's not going to do that. So we hope to have a decision on whether or not these are going to be put back on the front burner by roughly the end of the year. But even that decision isn't going to be final, because the next step certainly will be whoever loses is going to ask for, at the very least, en banc review by the Sixth Circuit, meaning not just a panel of 3 judges, but all the judges in the Sixth Circuit should hear this. And whoever loses that is going to go to the United States Supreme Court for further review. So we're a long way from done on this. But as matters stand right now, the ETS has been stayed and is not going to be enforced by OSHA.
Jim, I, in my line of work, have met a lot of attorneys. I'm not one of them, but I've met a lot of them, and I know all of them, at least in sometimes fancy themselves a future judge. So I'm going to put you on the spot and ask you, what would you predict that the Sixth Circuit is going to do?
Well, this is based on sort of all the tea leaf reading that I've been reading about from all the people who do watch the court very carefully. The Sixth Circuit right now is a very conservative court, given the appointments that occurred during the Trump administration, as well as in the second Bush administration. So it is a very Republican-leaning court. In earlier decisions that came down from the Sixth Circuit earlier in the pandemic dealing with issues of religious accommodation, they were very against restrictions being imposed by the states to prevent the spread of COVID. So I think, and this is my guess, and that's all that it is, that they are likely to uphold what the Fifth Circuit decided and say we're not going to enforce this OSHA ETS. And that will take it to the Supreme Court from there. And at that point, given the composition of the Supreme Court, I would be very surprised if they were resurrected at that point. But I've been surprised before.
So in your recommendation, Jim, what are you recommending clients do at this point? Because right now the mandate is being stayed, right? And the dates, one date we've already blown past, and I think you said beforehand you expect we're probably going to blow past the other date. So what are you advising clients to do? To plan for a mandate or not plan for a mandate? What's the best practice here?
So we're advising that you sort of steer a middle course. And if you look at what the ETS requires you to do, there's sort of two pieces of it. One is having some appropriate plans and data gathering in place. And that was really supposed to be done by December 6th. And then the second is actually having a mandate that all employees on the premises either have to be vaccinated or be getting weekly tests. And the due date for that was January 4th. What we're recommending is that you get your policies in order. And there are draft policies that OSHA has provided on its website. So making sure you have the paperwork ready to go when and if the stay is lifted. Also to gather information about which of your employees is vaccinated and which are not, because that's another thing that you have to have to comply with the OSHA ETS once this goes into effect. And you're not going to be able to pull that out of your hat immediately, if the stay gets lifted. So our recommendation is to gather that so you have it in place and ready to go, and have your policy in place and ready to go, but not to roll it out and actually implement it at this point, because we don't know that it's going to be a requirement to do mandating or testing. That said, some employers have already put mandates in place on their own, deciding that's something that they wanted to do, and there certainly are positives and minuses to that. But as far as compliance with what OSHA is saying, we think you should at least have the policies in place ready to go and gather that data so that you can provide it, because you can't do that at the last second.
We do have a question from someone who is listening in, asking about the timetable if this were to go into place. So I think it's timely since we're talking about this right now. So if we were to get to a place where, whether it's the Sixth Circuit or the Supreme Court were to say, you know what, this mandate's good, we want to put it back into place, and it were to happen, what kind of timetables do you think we'd be looking at? These 2 dates, we've rolled by one, we're likely to roll by another. How long do you think they would give employers to kind of put their plans back in place?
So technically they wouldn't have to do anything. They could say it's back and you need to be in compliance immediately. I think that's a pretty unlikely outcome, because there is work for employers that needs to be done. So I would think that whatever court ultimately rules on this is going to say it's going to go back into effect, if they were to say that, and then give a timeline of at least giving an additional 15 days for the policies and 30 days after that to get your vaccinations or testing policy in order, or some reasonable timeline, because even OSHA recognized when they rolled this out, you couldn't snap your fingers and get this done overnight. And OSHA on its website indicated, they were going to comply with what the Fifth Circuit did, and they were going to stop enforcement. So it seems like it would be incredibly inequitable for them to say, well, we're going to flip the switch and everybody has to be vaccinated magically overnight, because you should have known that this was going to get overturned.
Yeah, one thing we talked about earlier that I wanted to ask you about too, Jim, and we've got great questions rolling in from those who are listening in, so please keep them coming. But I wanted to ask you about, one thing at the Chamber, we do a lot of polling data and research on behalf of our employers. One thing we've learned over the course of the pandemic is that our workforce has shrunk, and people understand this because it's hard to find workers, right? But the workforce has shrunk pretty considerably, especially amongst people aged 50 to 64, and it's really because they're afraid for their own health, right? And so we already know that we've seen people leave the workforce because of health concerns, right? And part of the reason people are concerned about a vaccine mandate is because they think the workforce will shrink even further. So I guess my question to you is there, for employers, should they be worried about the other end of this from a legal perspective? If someone comes in while this vaccine mandate is on the books but not being enforced and gets sick, is there any legal concern there?
Well, yeah, there's a couple of legal concerns and then a practical one, right? I mean, so the legal concerns are, even without the specific ETS in place, Osha has said that they're going to enforce their general duty clause obligations. So all employers have a general duty to provide a workplace that's free from recognized hazards. And so if you have an outbreak that's tied to your workplace, it is possible OSHA could come in and say, look, you're in violation of your general duty clause because you're not requiring people to wear masks, or you're not having a vaccine mandate, you're not requiring social distancing, you're not doing those common sense things that we require people to do. That's one potential liability. The second is if someone gets ill at work because they're exposed to a condition, that's a workers' compensation claim. And there certainly would be a workers' compensation liability if they could tie their illness back to the workplace. I mean, of course, the difficulty in that circumstance is, how can you show you got sick at work versus at the gas station or at the grocery store or at the movie theater you were at? But that's a fact problem. But theoretically, there could be a liability issue there. But the third issue is the tension that you identified, right? That you've got some employees who are saying, if you have a vaccine mandate, I'm not going to come to work, I'm going to quit. And you got this other group of employees who are saying, because we don't have a vaccine mandate, I'm not willing to re-enter the workforce. I don't want to be out there. And the real question is, if a vaccine mandate gets rolled out, either on a nationwide basis or even company by company, will those people in that 50 to 64 age range come back into the workforce, or will they remain concerned enough about their health that they'll say, I'm not willing to take the bus to go to work? Or even with the vaccinations, given breakthrough infections, given the Omicron variant, all those issues, I'm still not willing to come back until things settle down some more. And that's the $64,000 question that no one knows the answer to.
So we're getting a lot of questions in here, Jim, about not other vaccine mandate related issues that maybe don't directly come with the ETS. But there's a question in here, for example, what does an employer do if they have a funding provider, for example, that's mandating vaccines? Even though this particular ETS has been stayed, does that apply when the funding provider is required?
So typically that will be a contractual issue, that if you have a funding provider that says as a condition of our contract, you're going to have to have all your employees vaccinated. That's a negotiation between you and your funding provider or whoever is giving you that money, whether or not you want to comply with it. Ultimately, if they want to impose that as a condition of continuing to receive funding, you're going to be in a very difficult position saying no. Ultimately, it's a contract issue, right? It's just a negotiation. Now, there's always going to be those exceptions that you're dealing with for religious accommodation, for disability accommodation, for those employees who had those legitimate objections that have been recognized even by the ETS that you'll need to deal with.
There's a question here, Jim. What about employers who want to require that new employees are vaccinated without requiring it for their current employees? Does that pose a problem? So, for example, I don't want to lose any staff over this, but I want to make sure anyone else I'm hiring has a vaccine mandate.
No, I mean, it's legally acceptable to do that. Again, you still have to be willing to accommodate and deal with people who have religious or disability related objections to vaccination. So you may have to accommodate in some ways by putting other things in place aside from vaccination. But no, you can have that different standard for people who are new employees versus existing employees. That's okay.
All right. There's a question in here about enforcement. So if this goes into place, and I think you said you expect the Sixth Circuit's a pretty conservative court, and you expect them to continue with the stay, and the Supreme Court, as we know, is pretty conservative. So your prediction is that maybe not this goes into place, but if it does, what does OSHA enforcement look like? We've got good employers at the chamber, so I'm guessing most chamber employers probably haven't had OSHA enforcement. What does OSHA enforcement look like in this type of instance?
So in Michigan, you deal with MyOSHA, which is an arm of the state. And there's really two ways you can end up with an OSHA enforcement action against you. One is that if you get selected for a random inspection, and that does happen from time to time. They tend to focus on manufacturers versus white collar workplaces. But that's just, one day an OSHA inspector shows up your door, knocks on the door and says, hey, I'm here to do your random inspection, and they'll go over the place soup to nuts, looking for broken switch plates and trip hazards and blocked exits and all the other things that you have to comply with under OSHA. The reality is that's probably not where most of the enforcement is going to come from in this place, just because there aren't a ton of OSHA inspectors out there, and they're already stretched pretty thin. What you're going to see more on the enforcement side is going to be complaints made by employees, so whistleblower type actions, where an employee is going to say, look, I heard about on the news you have to have this mandate in place. My employer is not doing it. They're not playing ball. And so they're going to call OSHA and say, my employer is not playing ball. And that will trigger OSHA coming in and doing that inspection and asking to see your records and all the things that you have to comply with the ETS if and when it went into force. Now, once they come in, the citations vary, right? They start with what's called an other than serious violation, which is a citation that typically you're going to look at, less than $700. Often there's no monetary fine, and it's basically OSHA saying you need to fix this, but don't worry about it from a monetary perspective. But most of these would be either serious or willful violations. So a serious violation is one where the violation has a likelihood of causing significant injury or harm to employees. They come with a $7,000 per violation fine, and then a willful violation or a repeat or a failure to abate, because one thing that OSHA requires is if you get cited, you have to then fix it and show proof that you fixed it. And if you don't fix it, then you're dealing with a failure to abate citation, which can be up to $70,000. Now, federal OSHA numbers are higher, and they're going to go higher still as part of the Build Back Better bill if that ever gets passed, the way that it's currently written. But federal OSHA has said they're going to look at these enforcement actions, and if you have an employer who doesn't do anything to try to comply, so we're not talking about a foot fault, they didn't collect all the data, they've got 90% of the data, they just couldn't get information from a couple of employees, or the masks that they're using aren't technically ETS compliant, but they're pretty good and close. There's that showing of we're doing our best and maybe it's a foot fault. We're not talking about that. If you have the employer who does nothing, federal OSHA has said we're going to look at that as such a serious violation. We're going to issue a serious violation for each employee that's exposed to that hazard. So, and the federal OSHA violations start around $13,000. So we're going to say you got 100 employees, it's 100 times 13,000. And now you're looking at some very big numbers. And I would expect to see a few of those in the federal OSHA area if this gets enforced, because they're going to want to put some heads on pikes, right? To say, here's some big companies, they're not doing it, and scare other employers into compliance. So I would expect to start seeing some of that pretty quickly if this goes into effect.
Well, Jim, you've just let me know I've been gainfully employed since I got a paper route as a 5th grader, and I never knew that OSHA was who I was supposed to call if I had an issue. Not that I have an issue with the chamber, they're a great employer, but I never knew that. So what about employers that may have some individuals who work on federal contracts, but not everybody?
So the federal contracting standard is a different standard. There were actually, as part of President Biden's COVID plan that he articulated back in September, there were sort of 3 separate mandates that went into effect at that point. There was the OSHA ETS mandate, which is what we're talking about today. There was the Medicare CMS mandate. So basically most recipients of Medicare and Medicaid funds would have to have a vaccination mandate. And then there's the federal contractor mandate, which is the one that we're talking about there. Now, all 3 of those have been stayed. So none of those are going into effect as things sit right now. As far as the federal contracting piece, that's a really specific question, and you need to know a lot about the facility at which the federal contracting is being provided and who's involved in that. So I really can't answer that in the aggregate. It depends on a lot of independent facts. So I'd recommend that you consult with your attorney about that one and have them walk you through that particular mandate, assuming it goes into effect, which again, we don't know if that's going to happen.
Well, while we're talking about the federal contractors and the CMS one, because we did have a question here about the CMS mandate as well, Jim, could you just give us an update on where those 2 cases stand as well? Are they both sitting in a circuit court waiting appeal, similar status?
The standard to object to those is different because if the OSHA ETS is a separate procedure as part of OSHA that you take those objections directly to the circuit courts. For the objections to the CMS mandate and to the federal contractor mandate, those were started in a district court, like you would typically file an action. So Eastern District of Michigan, for example, would be an appropriate forum to hear one of those objections. So district court judges have issued nationwide stays as to both of those. The next step will be for those stays to be appealed to the circuits from which they arose. One's down in Louisiana, and I think one's in the Sixth Circuit as well. And so that'll be the next step with those. But those haven't even been, notice of appeal hasn't been served yet, to my understanding. So they're a little bit behind the federal ETS. I think that it would be pretty likely you're going to see these all rise or fall together. I'd be kind of surprised if the contractor standard stuck and the ETS standard didn't. I think they'll likely to rise and fall together. But again, that's me reading tea leaves. So what it's worth. Yeah.
So a question in here, Jim. So the ETS right now, as it's written, applies to employees who go to the work site. It doesn't apply to remote workers. Is that correct?
Yeah, I mean, but by remote workers, we're talking about truly remote workers, right? Workers that never, ever come into the workplace. If they're dropping by once a week to pick up files and going home, they're covered. So when we're saying a remote worker, we're talking about a truly remote worker that does not set foot in the workplace.
Okay. So if you're an employer who truly has those types of remote workers, it's probably recommended that you really focus on gathering information on the folks in the office. Would you recommend that?
Well, you need to gather information about, so there's two different components, right? There's who's a covered employer, and a covered employer is any employer that has 100 or more employees, even if they're not all together. So in theory, you could have 100 employees, all of whom work entirely remote, right? And you would still be required to gather data about the vaccination status of those employees, but you don't have to have a mandate that they would be vaccinated to come to the office, largely because you don't have an office, right? So it's a little bit different circumstance. There's two different issues. One is who is a covered employer, which is basically anyone with 100 or more employees with some exceptions, and then who's a covered employee, and is an exception there for someone who never actually is in the workplace.
Okay. We've got some, again, we're getting some really good and great questions. I really appreciate it. I'm trying to get to as many of these as possible. So I'm going to apologize if I don't get to everybody's question. As far as the testing component of this, are rapid tests considered okay, or does it have to be a PCR test?
My recollection is that a rapid test is not an acceptable test, that it has to be actually, scratch that. A rapid test is an acceptable test for that purpose. There's a different component of the standard where a rapid test isn't acceptable. But for your weekly testing, a rapid test is okay, but it does have to be a proctored test. So you can't just tell the employee to go to CVS, pick up their swab, stick it up their nose, and then come in and report they did a test. You've actually got to proctor the test, either by having someone at the employer do it, or you can do a telecommunications proctoring. So if you've got a telecommunications service, you'll have a medical provider watch the person do the test and develop the results. That's also acceptable. But a rapid test is acceptable for the weekly testing.
And who has to pay for the test? There's a question here. Does the employer have to pay for the test? Because ultimately, I mean, I guess it's a choice of the employee, right? If they want to get vaccinated or they want to fall under the testing requirement, it would seem to me that shouldn't be the obligation of the employer unless they choose to make it.
So that's a little bit of a complicated question, believe it or not. So what the OSHA ETS says is that the OSHA is not requiring employers to pay for the test, but there may be other laws or requirements that would require you to pay. So what are those things? What could those things look like? Well, number one, this would be a subject of bargaining if you have a collective bargaining agreement. So if you're going to have a test availability for a collective bargaining unit, who's paying for that test is a subject of bargaining. So you're going to have to talk to your union about who's going to come up with the money to pay for the testing, the employee or the employer. Second, there are some states, such as California, Illinois, where costs of performing duties have to be paid for by the employer, and there's a decent argument that this would fall within that requirement of a separate state statute. So that in California, if you have employees who are getting tested there, you'd have to pay for that, even though the OSHA ETS doesn't require it. Separate California law might. Again, that hasn't been litigated out, but there would be an argument there that you would have to deal with. So you got those issues. And then finally, if the testing is being offered as a reasonable accommodation to religion, a religious objection, or a disability, under those circumstances, the employer has to absorb the cost. If the employee is saying, I'm just not getting vaccinated because I don't want to be vaccinated, and I think I have freedom not to do that, then the employer can say, well, then your decision is to pay for the cost of the test. That's a consequence of your decision. So it's a little bit more nuanced than that. Generally, an employer can push that cost back on the employee, but there are some exceptions.
Got it. So I guess we're getting towards the end of our time. There are employers that are making decisions about this completely outside of the context of the ETS, right? There were employers who were choosing to put a mandate in place before the ETS got put in place. What are you seeing in the marketplace amongst your clients as the trend?
So I think that for most of the employers that were going to do that, most of them have done it. That they bit the bullet and did it over the summer, and did the calculus for themselves of, are we willing to alienate some portion of our workforce to gain protection for the remainder? And do we think that vaccination is the gold standard versus masking slash testing slash social distancing? So I have not seen a lot of clients in, say since August, September, start adopting that vaccination mandate. There were a lot more of them in the April, May, June timeframe because that they sort of came to the conclusion then. Now, again, with the rise of the new Omicron variant, with the high spread that we're experiencing in Michigan, we may see a reversal on that with employers saying, we really don't want our workforce to be at risk given the higher level of community spread. So we're going to roll that out. But right now, I haven't seen a lot of my clients come back and say, okay, we've rethought this.
The last question I'm going to ask you, Jim, before we say thank you and recommend that if people have more questions that they consult with their own attorney, and if they need an attorney, they look you up. But now boosters are being recommended across the board for folks. I'm sure there are some exceptions, but do you see that becoming another hurdle for employers, where employers are going to be asked to mandate the booster, or do you think we're going to assume that full vaccination continues to be just the 2-shot routine or one for Johnson & Johnson? Or are we going to have this issue again with boosters?
The original ETS and the commentary to the ETS defines fully vaccinated as the 2-shot regimen or the single-shot Johnson & Johnson regimen. It says that's all you have to do. So to comply with ETS, that's what the requirement is. However, given the Omicron variant, I've seen some interviews with Dr. Fauci where he has said, we need to look at whether or not that booster is going to be required to be quote unquote fully vaccinated on a going forward basis. So I don't think that that's happening yet. I wouldn't be surprised, depending on how we see things trend in the next 30 to 60 days, if there starts to be some discussion of, okay, now we're going to mandate to be fully vaccinated, you have to have an appropriate booster. So that's me, again, reading tea leaves, but just kind of what I'm hearing, from government officials who'd be talking about this issue, what I'm reading in the press about it, I wouldn't be entirely surprised if that started to become the new gold standard.
Okay. Well, I think, we've gotten some great information from you today, Jim, and I know, this has been incredibly complicated. We're hearing from members about it and hearing questions all the time. I think you've gone a long ways to at least beginning to answer some of those. So I will encourage you, if you're listening in, if you've got further questions, always reach out to us and we'll try and help you find the answer. But if you got really in-depth legal questions, it's always best to talk to your attorney. And if you need one, Jim's a great one. Thank you, Jim, for helping us out today. And thank you all for listening in. And we look forward to seeing you again soon.
My pleasure. Thanks for having me.